All right, can I get someone at the courtroom there in the jail to unmute the jail court, please?
How's that, Judge?
Perfect, thank you, Deputy Phillips. All right, Ms. Thompson, are you ready with, is this Mr. Mark Walcott?
It is, Your Honor.
All right, this is cause number CR 21-347 and 348, State versus Mark Harrison Walcott. And are we set for a plea today? I see we're set for arraignment. Does Mr. Walcott want to enter a plea before the court today?
Your Honor, yes, sir, he does. We've already filled out the paperwork.
Okay, and I don't have that paperwork with me, so can either you or the state give me the terms of the plea?
All right, yes, sir. Hang on 1 second. I'm turning that page. With the plea of guilty, the punishment will be assessed at 2 years in state jail, probated for 5 years, a fine of $2,500, $180 in restitution. State will 1245 CR 21-00348, fraud, easing, or possessing identifying information. And a misdemeanor is DA 2021-0792 of a failure to ID as a fugitive.
All right, and are there must be some reimbursement fees also?
Yes, sir. $100 fine, $180 in restitution, $290 in court costs, $725 in attorney fees.
All right, I didn't catch all of that, Ms. Thompson. I caught the 725 reimbursements. Court costs, I'm assuming, are $290.
Yes, sir, $290.
$290, and are there any other? Is there? And there was restitution of $180,
Yes,
$290 court costs, $725 reimbursement fees. Were there any other financial obligations other than those?
Just the fine, Your Honor, $2,500.
$2,500 fine. Okay. All right. All right, Mr. Walcott, if you will, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, sir.
All right. Thank you, sir. You may place your hand down. If you'll just speak up loudly and clearly for me, I would appreciate it. Your name is Mark Harrison Walcott. Is that correct, sir?
Yes, sir.
And Mr. Walcott, we are set today for arraignment on 2 charges wherein you have been accused of possession of a controlled substance in penalty group 1 less than 1 gram, a state jail felony, and also a state jail felony offense of fraudulent use or possession of identifying information less than 5 items. Ms. Thompson has indicated to me that you wish to waive arraignment today and go ahead and enter a plea of guilty to each one of these charges. Is that correct, sir?
Yes, sir.
Okay.
He's only pleading to the possession of controlled substance. Your Honor.
Correct, but it's going to be a 1245, so he's going to be pleading guilty to that as well. Likely,
Yes.
is that correct? Okay. And so, Mr. Walcott, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss both of your cases with her and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir. I understand everything.
And you heard Ms. Thompson read the terms of the plea agreement to me. Is that what you're asking the court to approve today?
Yes, sir.
All right, Ms. Thompson, you do believe Mr. Walcott to be competent today. Is that correct?
He is competent, Your Honor.
And you've explained to him his rights and the law as they apply to him in these cases. Is that correct?
Yes, sir, I have.
And you believe he understands?
He does understand, Your Honor.
All right, Mr. Walcott, the range of punishment for a possession of a controlled substance in penalty group 1 less than 1 gram is, if you are convicted and sentenced, the range of punishment would have to fit within the minimum, which is 6 months confinement in state jail, up to the maximum 2 years, and a fine not to exceed $10,000. That's the range of punishment. I see here in this case that you would be agreeing pursuant to the plea agreement for your punishment to be assessed at that maximum 2 years in prison today. But the court would be suspending that and placing you on community supervision for 5 years. Do you understand how the range of punishment works, Mr. Walcott?
Yes, sir.
All right. And so, Mr. Walcott, understanding the range of punishment for this charge, understanding the plea agreement, at this time, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony?
Guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt. Ms. Thompson, any objection to the state's evidence?
None, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
From the defense?
No, Your Honor, we'd like to close.
All right, and Mr. Woodwhite, can you give me the summary of the evidence to support the plea?
Yes, Your Honor, on the date in question, the Canton Police Department responds to a call that 2 males are in a house that the owner is currently in the hospital. Canton arrives, makes contact with the defendant and his friend, and he states that it is the defendant's stepfather, and he's cleaning it. Canton Police Department confirms with the owner. In doing so, attempts to identify both subjects. Defendant hands over a Green Mountain Recycling ID card, which is his deceased brother's. It comes back deceased. Defendant admits his real name and that he believes he has a warrant. He gets arrested. He then turns his car over to his friend. Canton Police Department does an inventory before turning the car over to the friend and locates a bag of meth, 0.39 grams, in the driver's side mat pocket in an aspirin bottle.
Thank you, Mr. Woodwhite. Any objection to that summary, Ms. Thompson?
No, Your Honor.
All right, and based on the evidence as presented, the court finds that there is sufficient evidence to convict Mr. Walcott of this crime. Court will follow the plea agreement in this case. The court convicts Mark Harrison Walcott of possession of a controlled substance in penalty group 1, less than 1 gram, a state jail felony. The court assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence today and place the defendant on community supervision for 5 years. Order him to pay a $2,500 fine, $290 court cost, $725 reimbursements, $180 restitution. Court will take into consideration and dismiss under section 1245, cause number CR 21348, and misdemeanor cause 2021-792. Mr. Walcott, you understand that once you're placed on community supervision, if you violate any of the terms and conditions of your community supervision, the state can file a motion to revoke your community supervision and impose that sentence upon you, wherein they would come back and they would have to present evidence to me and prove to me that you violated any of the terms and conditions of your community supervision. And if they do so, then you understand that your sentence is already assessed at 2 years. You understand that?
Yes, sir.
Okay. All right. Then you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with the deputy to be fingerprinted. After that, the probation officers will give you more information.
Thank you.
You're welcome. Ms. Thompson, is that all you have?
Yes, Your Honor, that's all I have.
All right. Thank you, ma'am.
Oh, I gotta finish filling that.
No,
Okay.
You're right.
Do it all right.
All right. This is cause number CR 21317, State of Texas versus Joseph Dan Aguado. And we are just having a status on the competency restoration. Not sure what number he is on the Terrell State Hospital list, but in April he was number 204. Have you received any update, Mr. Stevens?
I have not, Your Honor.
Okay. And how is Mr. Aguado doing after having been administered the mental health medications? Better?
He was able to respond to me for the first time in 4 or 5 meetings. And he's still not there, but he is doing a little bit better.
Okay. Do you believe that the mental health medications are helping your client?
I do believe they are, Judge. Slowly. I don't mean it's a big
Sure.
But a little progress, yes, sir.
Okay, good. All right, then let's reset Mr. Aguado for another status. We'll set him. Do you have your calendar for August?
I do, Judge.
Let's set him late August, August 23rd. Are you available on that date?
Yes, sir.
Okay, August 23rd at 1:30, and we'll see where he is. And of course, Mr. Stevens, as you're aware, if there's any issues that come up between now and then, you let the court know and we can get him on the docket sooner, address any issues we need to.
Yes, sir.
All right, August 23rd at 1:30. Thank you, Mr. Aguado.
Thank you, Judge. Might be excused.
Yes, sir. Is that all you have this afternoon?
Yes, sir. Your Honor.
All right, thank you, Mr. Stevens. I appreciate it. Mr. Green, are you ready?
I am ready, Your Honor.
All right, this is cause numbers CR 1688 and 89, State versus Thomas Logan Bailey, and I believe that we are set for status. Can you bring me up to speed?
Judge, Mr. Bailey was recently released from the Louisiana Department of Corrections. At the time he was released, he had a hold on him for this case, or these two cases here in Van Zandt County. He was in custody for about 8 years, 7 years, 4.5 years. I'm sorry, Judge. He had an 8-year sentence. I need a little time to visit with the state, also to look at the clerk's file about what appropriate back time credit would be for Mr. Bailey. So we're not ready to proceed today in either way.
Okay. Do you anticipate needing any contested hearings, or do you think this is going to be an issue with credit time and fashioning some kind of plea? The reason I ask is I want to know what to set you for, either pre-trial, give you a chance to file motions, or just set it for docket call and give you time to work on the credit time issue.
Judge, back before he was taken into custody in Louisiana, we did have some pending motions to suppress. We had moved along the case for a couple of years, so I don't have any motions that I need to file, and I do have pending motions that we may need to hear. And I think it'll depend on the back time credit and what the state's position is on any offer that they may be willing to make to resolve it.
All right, I would propose that we set it for docket call, and then if there's no agreement, then the court will allow you to get on the evidentiary docket to urge your motions.
Okay, that'll work, Judge.
So let's look about 30 days, gives the state some time to deal with that. We can do it sooner too if needed. Right now in July, I've got the 7th, the 19th, and the 21st available.
Judge, the 7th and the 19th, I will be out of the office on vacation, but I do get back in on the 20th. If we could do it on the 21st.
Okay. All right, we'll set Mr. Bailey then for a docket call on July 21st. That'll be at 1:30.
And so he will be here or at the courthouse?
He'll be there at the Justice Center.
7/21 at 1:30.
Yes, sir.
Okay. All right, Judge.
Thanks, sir.
Yes, sir. Thank you. May we be excused?
Yes, sir. Good to see you. All right, Mr. Ashmore.
Judge, I'm here on Damian Wilson.
All right. this is cause numbers CR 2234, CR 2373.
Judge, we've got a resolved negotiation with the state for 8 on all matters. We're going to ask the court to reset us to plea that if possible on Thursday of this week. And I know Miss Abney's out today, but if the court has room on the docket for Thursday, that'd be our request.
Okay, we'll set Mr. Wilson then to enter his plea on Thursday of this week, that being June 16th. That'll be at 1:30.
So. Yellow was yours.
Who are you ready on next, Mr. Ashmore?
Cody White, Your Honor.
Cody White, CR 21346. Mr. White is set for docket call.
Got a docket call, Judge. We have a 3 deferred offer. There was an issue with accepting that because Cody was homeless at the time he was arrested. We have an address. We're squaring that away. I've already talked to probation. If that address is solid and he can report from there, receive mail from there, then we're asking again also to come back on Thursday and finalize that plea agreement that we couldn't last hearing.
Okay, so he's going to enter his plea on Thursday.
Yes, Judge.
All right, court sets Mr. White to enter his plea Thursday at 1:30.
Vicky, I'll let you know. Okay. Judge, Mr. Shackleford.
This is cause number CR 22117. Mr. Shackleford set for pretrial. Go ahead, Mr. Ashmore.
Judge, we have a plea offer of 22 months with a $500 fine or 18 months with a $1,500 fine. We'll reset that to plea also on Thursday, if possible. Receive communication from the state. They can have that paperwork ready. And if that's all right, we'd like to do that, take care of Mr. Shackleford's business in Van Zandt on Thursday.
All right, court will set Mr. Shackleford to enter his plea on Thursday at 1:30.
Mr. Spriggs, Your Honor, I filed unfortunately yet another pretrial motion.
This is cause number CR 21371, State versus Casey Lynn Spriggs. Go ahead.
Okay, Judge, so the Dallas County Medical Examiner will not talk to me without some money from Van Zandt County. So they want $255 an hour for Dr. Lenfest, who's the authoring medical examiner. And that being said, I mean, I've represented to them that I'm a court-appointed attorney for an indigent defendant, and that went absolutely nowhere. So I've got a W-9 from Dallas County. I've got the 2 forms memorializing that. I don't believe they were attachments, but I can certainly email them to Patty and Miss Waynette. But that is our respectful request. I'd like to speak to Mr. Lenfest because time of death is an issue in this case, and we believe he's the material sponsoring medical examiner among the multitude of people at Swift that worked on this investigation. So we're going to ask the court for a reset, one more pretrial, I'm sorry, and also to authorize or redirect some of those funds for that investigator. Maybe they could be repurposed for this, which I think is more important for the case.
And so the forensic pathologists, they understand that you're just wanting to ask questions about it, not to retain them as an expert. That you're telling me that they want you to pay them
Yeah.
public money so that you can talk to them on the phone about some issues.
Well, I mean, he's only in Dallas. It's only about 43 or 45 miles from our office. And I'd be willing to go down there, right? I mean, and yeah, that's my, to answer your question, I apologize. To answer your question, I've twice said I'm a court-appointed attorney for an indigent defendant where Mr. Lindfest has authored a report where he's the material witness on time of death, cause of death, things like that, that are material to this matter, a homicide in Van Zandt County, and I've been twice given, please pay our fee. So, I mean, my initial thought was to call up Clay Jenkins and tell him what I thought about that, but not being a Dallas County voter, probably wouldn't care what I had to say about it. And that's where that is. So that's our request. I think it's a ridiculous position for a government medical examiner to make another county pay for their time, but that is what I've been told is the only way I'll talk to Lindfest, by his gatekeeper.
I think there is an alternative way that you could speak with someone. I mean, it's going to be under oath, but it's called the power of subpoena.
That's true, and a pretrial subpoena to take the deposit. Well, I didn't want to go down that road of ugliness.
Sure. So
I didn't before getting a call from Clay Jenkins' office about who's this upstart lawyer you got, blah, blah, blah.
Right. Let's before we expend the Van Zandt County taxpayer money on another public official in Dallas County, perhaps you can go and request once more and give them the option of either speak with you on the phone and you go visit their office, what have you, or if they would rather do that with a subpoena and an evidentiary hearing, then we could conduct an evidentiary hearing to get the evidence that is due to the defendant. So let's do that before I authorize money, before we divert any of the money from the investigator to the forensic pathologist. So, and then I will also on my end try to figure out if there is a miscommunication, because I've never encountered that, and I'm not sure if the state's encountered that either.
Yeah, I spoke to our appellate lawyer, who's I've never had that happen in any case where Swift in Dallas has been involved, where they're like, give us money before we will talk to you. I've kind of unheard of.
Perhaps an email, something in writing, so that we know what was conveyed to them clearly.
Yes, sir.
And then if they deny, then I would set you for an evidentiary hearing, and we could come down on a docket and we could spend the day.
Okay, Judge, that sounds good to me. Thank you.
You're welcome.
Again, not trying to slow this matter down, but it is a first-degree murder, and we just want to make sure that we're doing everything we need to do with a fine-tooth comb on the evidence, some of which was not looked at, resolved, analyzed. It was produced for Van Zandt County in another county. So I appreciate that, Judge. And if we can have maybe a little bit longer reset, because there is going to be an Independence Day holiday between now and the next 7/19. I don't know where Lindfest is going to be between now and then, but I'll put together strongly worded correspondence and also whatever documentation they need showing that I'm the court-appointed attorney for Mr. Spriggs. So that way the gatekeeper will communicate maybe to him directly. These are our options, Mr. Lindfest.
All right, let's set it I'm going to set it on the evidentiary docket for August 25th. That way, if you have no luck, then you can just issue your subpoena, and then we can go forward on the 25th. That way we don't have any unnecessary delays.
Okay, Judge, thank you so much. Thank you very much. Judge, Ms. Rheem.
Tamara Rheem, CR 21366.
Judge Tamara Rheem. And Judge, we still have this issue to resolve as to whether she has a new charge or not. We don't yet quite have a plea on the DWI third. And, well, we don't have an offer. We don't yet have an offer. But Mr. Woodwhite was not sure whether she was in custody because there was issue with the Sheriff's Department computer system, as well as the online portal for defense access, the LGS system. So really, the last time we were here, nobody knew if there was a new charge on, that's my understanding, that there's a new PCS, and we'd like to resolve all these matters together if there is. And we'd ask for a reset so the state and I can resolve that.
State.
Judge, based on our system, I'm looking at it right now. We still don't have record of a new charge, but I do believe that she's been booked in on a new charge. So if we could maybe recall her for Thursday and I can get to the bottom of this, maybe hopefully have a better idea. And we can make a substantive announcement for her so we can get her resolved one way or another on this. And Mr. Ashmore, if you'll call me once the docket is over and I can investigate this further, maybe we can discuss, can't see if we can't figure something out.
Right. Thank you.
Will we be resolving the case if there is not a new charge?
If there's not, I have no doubt we could reach an agreement. If there is, I need to figure out what that is, and hopefully we can try to wrap it into whatever resolution. It might change the resolution slightly on her older cases, but my hope is that we can get her resolved on Thursday.
Would that be a time resolution or a probation resolution? Here's why I ask. I'm already overbooked for Thursday. The only ones that I'm putting on Thursday are the ones that are for sure pleas. If she's not a for sure plea, I don't want to put her on Thursday because I'm already pushing 80 cases.
Okay, Judge, I totally understand that. And part of our issue is we just have not been able to know one way or another, and would prefer to resolve all matters together, especially if is there any room on the?
We could do the 28th. That's 2 weeks.
That would provide the state plenty of time. I would set it at Mr. Ashmore's in the court's convenience, Judge.
I'll move some things that were available on the 28th, and that way we can figure this out because.
Okay, court's going to set Ms. Rheem for June 28th. That will be at 9 a.m. and that will be in the courthouse. 9 a.m. in the courthouse.
9 a.m. Understood, Judge.
And I'll have Ms. Rheem brought over.
And Judge, if we can if we can figure this out as soon as possible, would it be possible if we do reach a resolution to get it done on Thursday? I know we're at capacity, but if we can have a set plea, get it done, get it resolved, would it be possible if Mr. Ashmore communicates with the court?
Yes, if you work out an agreement, we can do it on Thursday. But like I said, I only want to put people on Thursday at this point if I know they're going to be resolving their case. I don't want to come back and have announcements like, oh, we're not sure, could be possible, we would like for. I don't want any of that. It's either got to be, yes, it's a resolution. If it's not, then we'll put on another date where we're not packed.
That's perfectly acceptable. Thank you, Judge.
Okay.
Thank you so much.
Judge, we're ready on Alex Manus as well, but I'll wait till you call the case.
All right, this is cause number CR 2182, State versus Alex Chad Manus. We're going to do today's hearing's status on his Competency, the court is going to waive the appearance of Mr. Manus due to his mental health status for his own personal safety and the safety of those in the jail courtroom. Go ahead, Mr. Ashmore. Any update from the court?
Yes, Judge, I got here early and with Deputy McLeish's assistant and the nurse, Miss Lisa here at the Van Zandt County Justice Center, we went back to visit. We were under the impression he was having a better day. That didn't go particularly well. I do think that it is in his safety as well as the people in this courtroom best for Alex to stay back there, unfortunately. I also had a moment to confer with the state on this matter. I understand that to expedite Alex getting a bed at the Terrell State Hospital, there's a motion filed. I think it's already been on file in ESER to release Alex to the Terrell State Hospital today. And since that's what we have been waiting on. I can't remember. Sorry, there's a young man in here. That's the status, Judge. We're still waiting on that bed. Alex is taking the medication that was prescribed previous hearing. The nurse reported to me that he's taking it and he's doing well. And generally, when he understands that either the court will be disappointed or he's going to have an opportunity to see the court, he does better. However, that didn't work as planned today. So that's our status report, and the faster we can get him to Terrell, I think the better it'll be for Alex.
Judge, as Mr. Ashmore said, the state is filed. It should be in your e-file queue. There is a motion to dismiss on file. State does not believe at this time, given his number, that he will even reach the state hospital prior to the expiration of the possible sentence on this state jail felony. He's already been in for over a year. I don't anticipate that he would make the state hospital prior to the expiration of the 2 years that we can hold him under the law. We have arranged with the sheriff's department that once he is released, he will be taken to the state hospital on an APAL, and that they are coordinating that to get him hopefully evaluated and allow the state hospital to begin their work as soon as possible.
What would be the expiration of Mr. Manus's sentence? What's the longest we could keep him in custody before he expires? Show was filed in March of 21. Assuming his arrest date was prior to that.
I would assume as prior to that. I don't have his name. If the court would provide me a moment just to look that up.
Well, just to save time, I'm going to go ahead. I'll take the motion under advisement. And then if you'll give me that information, Mr. Woodwike, if it's not apparent from the court records, I'll look myself too, but I'll take that motion under advisement. We're going to reset Mr. Manus for another status. And the court will rule on that motion between now and that status. Let's reset. Are you coming back in July, Mr. Ashmore? Can't remember if we set you earlier today for. Looks like we have you coming back on the 19th for Miss Hunter. Yeah, so let's go ahead and we'll set Mr. Manus then on a status for July 19th.
Okay, thank you. Just lost my calendar. That works. Thank you.
Judge, I will get you a better calculation, but it appears as though he was originally arrested on 5/13 of 2020. He did make bond for some short period of time, I believe 2 or 3 months, but then he was arrested again, if my calculations are correct, in looks like June of 2021 and has been in custody since that date. So almost a year on that, plus probably a month or two on the first time before he was released on a PR bond. So has at least, I would say, 14 months back time at this point. And considering his number, I believe, is still in the hundreds for the restoration bed. We just don't believe that he's gonna get to zero before that. Or if he does, he won't have enough time to actually go through the restoration process.
Okay. All right, the court will review the state's motion to dismiss, and we'll revisit that on July 19th.
Thank you, Your Honor.
Thank you, Mr. White. Is that all you have, Mr. Ashmore?
It is, Judge. May I be excused?
Yes, sir. Thank you. Appreciate your work today. Is Mr. Gurley in the courtroom?
He is, Your Honor.
I'm going to bring Mr. Adams. He's going to be appearing via Zoom, and I believe he's joining us right now. All right, this is State versus Jeffrey Lance Gurley. I'm not going to read all of the cause numbers, but Mr. Gurley was set for pretrial in CR 21384, and then the subsequent cases beginning with CR 22136 and continuing through CR 22145 were all there was waiver of arraignments filed, pretrial granted for today, June 14th. Mr. Adams, announcement on pretrial.
No significant pretrial to take up right now, Your Honor. I would advise the court that we are in negotiations with the district attorney's office about a possible resolution by plea agreement, but we're not there yet.
Okay. Do you need additional time to review the discovery and the new charges? And are you requesting another pretrial, or do you may just set you for a docket call and then allowed you to urge any motions if you need to?
I imagine all of the discovery materials for these 10 new cases is going to be the same. I'm comfortable, I think. Well, no, out of an abundance of caution, I would think the best route for me conservatively would be to set us for another pretrial hearing so that I can review the new discovery materials to the extent that there is new discovery material for any pretrial issues.
State, any objection?
No, Your Honor.
30 days sufficient, Mr. Adams?
Yes, Your Honor, that'll be fine.
July 19th or 23rd. Did we set you this morning for? Yeah, which one would you prefer? 7/19 or 7/21?
It was either 19 or 21.
Yes, sir.
19 is fine, Your Honor.
All right, court's going to set all of these cases to run concurrently on pretrial, July 19th at 1:30. If Mr. Gurley makes bail, then it will be at 9 a.m.
Yes, sir.
All right, thank you, Mr. Adams. Thank you, Mr. Gurley.
Thank you, Your Honor.
Yeah, there's feedback on mine. There's sometimes it gets squirrely like that. All right, Mr. Wilson, how are you today, sir?
Good, Your Honor. How are you?
I'm doing fine. Do you have Mr. Eddington with you?
I do.
Mr. Eddington, if you'll step up, sir. This is State of Texas versus Keith Allen Eddington, CR 22132. Mr. Eddington is set for a plea today. Is that correct, Mr. Wilson?
Yes, Your Honor.
All right, and I had a note here. Does Mr. Eddington have a hearing issue?
Yes, Your Honor, he does. He reads lips,
Okay,
but he does have a little bit of a hearing issue.
okay. And if he needs to move closer to the monitor, if you need me to speak up, just let me know, okay? Mr. Eddington, can you hear me okay? Can you hear me okay? Mr. Wilson, would it help if we had some headphones for him?
I believe it would. I didn't know if any were available.
Give me a moment and let me check on that. Be just a second, okay?
We could turn the TV too, so. We just want to make sure. That, but they not connect to us. I know they connect to the cell phone. I think
Bluetooth
we can also
compatible.
just turn the TV on. Would that be discussion, I think? I'm not sure. I'll go ahead and try.
Your Honor, if you're available, we are. Oh, he's connected.
Mr. Eddington, can you hear me?
We're not connected yet, Tyler.
And that's a no. I'd assume that's a no.
It still says joining. Is your signal, what, are you on a cellular connection or are you on the Wi-Fi out there?
I don't know.
Because it's not bringing you in. I'm thinking your signal is probably not strong enough.
Yeah, it looks like it's on a cellular cell signal, Your Honor.
I just turned Wi-Fi off. No.
Yeah, you're probably gonna want Wi-Fi on. If you could get on the Wi-Fi, that would be better.
Take the TV Bluetooth.
It is, but then I can't hear.
It's so public. It says I'm connected to SO Public. You know what Wi-Fi you use back here?
I don't. No, I'm actually not connected to anything. Wi-Fi.
I've admitted you again. This says joining.
Oh, it's so helpful.
It's a good idea.
Do what?
All right, Deputy McLeish, Detective King's on his way out there to execute a warrant. I'm gonna send a laptop and our headphones and just ask that you, he's on his way and then they can just bring it back. So, Mr. Wilson, I'm sorry for the delay, but just have a seat, you and Mr. Eddington, and then we're gonna send a laptop out with some headphones and then he should be able to hopefully hear better. It's important. It's gonna be a plea today. So I want to make sure that he understands everything clearly.
Absolutely. Yes, Your Honor.
So sorry for the delay. It just seems like Deputy McLeish's phone is probably not picking up a good enough signal to let her join.
Would you try one more time?
Sure, absolutely. Maybe third time's a charm. I show you in my system twice now. It shows that see your face there. See if it connects to audio.
It looks like it's connected, Your Honor.
Well, it says connecting, so not yet. I've got your video, but I don't have your audio. No, but yeah, we can text there. Yeah, I just don't think the video, I don't think the signal, okay, it says connected audio now. Mr. Eddington, can you hear me okay? Thumbs up if you can.
Yes, sir.
Okay, good. All right. Go ahead and take it just in case it fails. We're going to send Detective King out there with it. He's on his way just in case, but we'll try to go forward. Mr. Eddington, if there's any time that you can't hear me, then you just let Mr. Wilson know and we'll stop, okay?
Yes, sir.
Is this better for you? Can you hear better?
Good.
Okay, good. All right. I'll try to still speak up. All right. This is cause number CR 22-132, State versus Keith Allen Eddington. And Mr. Eddington is charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. And I show that we're set for a plea today, Mr. Wilson. Is that right?
Yes, Your Honor.
All right. And Mr. Wilson, can you tell me what the terms of the plea are?
Yes, Your Honor. It is 7 years, TDC probated for 7 years with a fine of $2,500, which includes the $100 EMS trauma fine. Or I'm sorry, the family violence fine.
All right. $290 court costs,
Yes, Your Honor.
reimbursement fees,
$770, Your Honor.
770.
Yes, Your Honor.
Any restitution?
No, Your Honor.
All right, so 7 pro 7, $2,500 fine, $290 court cost, $770 reimbursement fee.
Yes, Your Honor, that's correct.
All right, Mr. Eddington, the range of punishment for this type of charge is confinement in the Texas Department of Criminal Justice. That is the penitentiary system for not less than 2 years or more than 10 years confinement, and a fine not more than $10,000. That means any sentence in this case would have to fit within that minimum of 2 to the maximum of 10. It appears that the plea agreement is today that you're going to plead guilty to this offense, and the state's going to recommend by way of your plea agreement that the court assess your punishment today within that range of punishment at 7 years confinement in prison. But then the state's recommending to the court that the court suspends your sentence and places you on community supervision or probation for a period of 7 years. And also that the court assess a fine of $2,500. You would also be ordered to pay court costs and reimbursement fees. Is that your understanding of the plea agreement today, Mr. Eddington?
Yes, sir. I understand.
Okay, so at this time, Mr. Eddington, I've admonished you as to the range of punishment. I've admonished you as to the plea agreement in this case. At this time, I'm going to ask you, how do you plead to the third-degree felony offense of assault of a family or household member by impeding breath or circulation?
I plead guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
I am guilty.
Has anyone threatened you or forced you to plead guilty today, Mr. Eddington?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. Mr. Wilson, any objection to state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Is there any victim notification issues, or are you in compliance with victim notification on this kind of charge, Mr. Woodwhite?
Judge, the state is in compliance. We sent a victim impact statement to the victim. We have not heard back.
All right, thank you, Mr. Woodwhite. Anything further from the defense, Mr. Wilson?
No, Your Honor.
All right, Mr. Woodwhite, can you give me the facts to support the plea?
Yes, Your Honor. On the date in question, which was February 9th, the sheriff's office was dispatched to a address here in Van Zandt County regarding an assault. Upon arrival, the victim, Mr. Justin McCarter, who is the defendant's stepfather, exits the residence stating that the defendant had choked him to the point he thought he was going to pass out. He gives a statement that there was an argument. Mr. Eddington had poured water on the wood burning stove, which had filled the residence with smoke or steam. And that in Mr. McCarter trying to stop that, Mr. Eddington placed his hands around his neck and made it difficult for him to breathe. Additionally, on scene was Miss Eddington, the defendant's mother, who corroborates Mr. McCarter's story that Mr. Eddington had in fact choked her husband, and she's the one who called police.
Thank you, Mr. Woodwhite. Any objection to that summary, Mr. Wilson?
No, Your Honor.
All right, then based on the evidence as presented, the court finds that there is sufficient evidence to convict Mr. Eddington of this offense. The court will follow the plea agreement in this case. The court hereby convicts Keith Allen Eddington of assault of a family or household member by impeding breath or circulation. The court assesses his punishment at 7 years confinement in the Texas Department of Criminal Justice. The court this day will suspend that sentence and place Mr. Eddington on 7 years community supervision. Court orders him to pay a $2,500 fine, $290 court cost, and reimbursement fees of $770. Mr. Eddington, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of your sentence. In just a moment, I'm going to have you step over with a deputy to be fingerprinted. Have you ever been on probation before, Mr. Eddington?
Yes, sir.
All right, so you understand what's required of you when you're on probation?
Yes,
You
sir.
understand, And you understand that if you violate any one of the terms and conditions of your probation, the state can file a motion to bring you back before the court and ask the court to impose the 7-year sentence if they prove a violation in your case. Do you understand that?
Yes, Your Honor.
All right. I expect you to be on probation and to comply with every term and condition. Do you understand?
Yes, sir.
All right. You're hereby remanded to their custody. Step over with the deputy to be fingerprinted.
Yes, sir.
Thank you, sir.
Your Honor, that's all I have on the docket. May I be excused?
Yes, thank you, Mr. Wilson. I appreciate your patience in allowing us to get this set up for Mr. Eddington.
Absolutely. Thank you, Your Honor.
5 gold stars to Deputy Aaron McLeish of the Van Zandt County Sheriff's Office for going above and beyond the call of duty.
Yet again.
Yet again, like she's running out of wall spaces for all the plaques that this woman has in her professional career. Like it's time to get a bigger office.
Time to get a new pair of boots.
All right. And just for the record, I believe that there was a writ set today that's been reset at the defendant's request. That was the writ in the case of Esteban Mendez, Mr. Carl Day counsel, and that's been reset until July 7th at defendant's request. All right, I believe that concludes the afternoon docket at the Van Zandt County Justice Center. I appreciate everyone's help. Tell the jail I appreciate all their help. Thank you, Deputy Phillips, Deputy McLeish. And we're going to be adjourned at this time.
Thank you, Your Honor.
Thanks, Judge.